Minister and the researchers and the supporting staff of the Portfolio Committee. And it will be presented by Ms. Lindekohle Gumane. And I would like to reiterate that this is purely a presentation that is being done by her, and that there will not be questions raised to her because she's not in a position to be able to answer any of the questions. This is for information purposes and for strengthening of the work that we have done, and also to ensure that we follow the proper procedures and processes of this type of work that we do in Parliament. So with that having been said, I want to make sure that we get attendance and apologies. And we're going to ask, who will be doing that? Mbali?
Morning, Chair.
Thank you.
In the meeting we have Dr. J. Come again, sir.
I'm just giving your surname. I called you on your first name.
Oh, okay. In the meeting we have Dr. Jacobs, Ms. Gela, Dr. Harvard, Mr. Klaba, Ms. Clark, Ms. Wilson, Ms. Ishmael, Mr. Van Staden, and Mr. Imam Sheikh. I only have one apology from Mr. Siwela.
Thank you very much. And then, honorable members, we're going to get an indication who is here from the department, National Department of Health. You're also very welcome. Who will give us that indication? I think I saw Dr. Crisp, and I don't know who the others are on the platform.
Morning, Honourable Chair. Morning, members, and everybody else present on the platform. Thank you. Yes, it's Nicholas Crisp here. I'm expecting that Dr. Tolari is likely to join. Some of us are abroad at the moment. I see from the department also Ntobeko Mpanza, one of the directors in our branch. Yeah, and that's the two of us at this stage. Thank you, Chair.
Thank you very much. And from the State Law Advisors?
Good morning, Chairperson. The State Law Advisors present today is myself, Aisha Johar, and Theodore Hercules. Thank you.
Thank you. And from the Legal Services Parliament?
Good morning, Chairperson and members. Sue-Ann Isaac from Parliament's Legal Services is present. Thank you.
Thank you very much. Honourable members, before we proceed, I'd like to remind you that this virtual meeting is deemed to be in the precinct of Parliament and therefore constitutes a meeting of a committee of the National Assembly for official purposes only. In addition to the rules of virtual sitting, the rules of National Assembly, including the rules of debate, apply. Members enjoy the same powers and privileges that apply in a sitting of the National Assembly. Members should equally note that anything said in the virtual platform is deemed to have been said to the House and may be ruled upon. All members of logged in shall be considered to be present and are requested to mute their microphones and only unmute when recognized to speak. This is because the microphones are very sensitive and will pick up noise which might disturb the attention of other members. When recognized to speak, please unmute your microphone and connect your video. Members may make use of the icons at the bar at the bottom of their screens, which has an option that allows a member to put up his or her hand to raise points of order. The Secretariat will assist in alerting the chairperson to members requesting to speak. When using the virtual system, members are urged to refrain or desist from unnecessary points of order or interjections. Honourable Member, I'm going to add over to Ms. Gumane. You had received this matrix via the email system. You would have had an opportunity to go through it. And as I reminded you earlier, this is not a question and answer session with Ms. Gumane. This is purely for information purposes so that we are all aware as we continue with the work which we are planning to do within this week and next week, that we have received the information and we're able to engage and use this information in our further deliberations and engagements. Thank you, Ms. Nkumane.
Thank you, Chair, and thank you for the warm introduction. Good morning to the honorable members. Good morning to colleagues and everyone present. Chairperson, just to indicate that I cannot operate my camera, so unfortunately I can't show my face this morning. I've tried with ICT, but they didn't succeed. So
It's fine.
All right, Chair, let me share my screen. Chair, can you see my screen?
Yes, I can.
All right, so just to start off, thank you for that introduction to give context to this document that I'm about to present. That it summarizes all the viewpoints and recommendations and proposed amendments of stakeholders from the different phases of the public participation process. That is the provincial public hearings, the written public submissions, and the public hearings in Parliament. I must indicate that this matrix is not exhaustive. We've developed reports, comprehensive reports, and we've also prepared synopses for the members to go through, which are just the summaries of the comprehensive written submissions that we received. And then this matrix just highlights the pertinent issues and key points that were raised by stakeholders. Just to kick off with the preamble, there were views that the preamble provides a vague description of how the NHI will be funded, and much of the detail pertaining to the sustainability of the funding mechanism related to the NHI is either lacking or unclear. There was a suggestion that a clause should be added that addresses the social and economic determinants of the disease, which should be done in cooperation with other sectors. And then further recommendations were that quality personal health care under the preamble should be emphasized as a separate point, and financial protection should be defined and should be checked against the Competition Act. On clause 1 under definitions, this highlights some of the definitions found to be inadequate and needs to be strengthened. For example, the primary health care was said that the definition fails to capture the spirit of the primary healthcare approach as defined in the Alma-Ata Declaration of 1978. Some were of the view that the definition doesn't capture allied health professionals, and that it should mention environmental health or municipal health services, and that it should also include palliative services. Emergency medical treatment should be defined so that there's a common understanding. Health professional, it was said that the bill exclude pharmacists and pharmacy support personnel, and it would not be possible to implement NHI without these professionals. And then on health services, it was said that the definition is vague and it does not cover all the health services as defined in the National Health Act, and provincial, district, and municipal health services are not clearly defined, and that it should also include environmental health and make reference to a legislation where municipal health services has been defined. Primary health care nurse, it was said that it should be defined based on the South African Nursing Council definition. And that primary healthcare nursing professional is a category not recognized by SANEC and must be removed from the bill. Ambulances, it was said that although the bill defines emergency medical services as inclusive of medical ambulance services and only provides for one payment mechanisms, it fails within the exclusive, it falls within the exclusive jurisdiction of the provinces. Health goods and health products, the use of the terminology, it was said that it's unclear and needs to be redefined, and they even sponsored some proposals on how it should be structured. And then in terms of the definition for health related products, it was said that it should be removed from the bill, and the correct term should be health goods or health products, with the reference for health products, as this is internationally accepted in terms of how the WHO has defined it. Complementary cover, as read with the provisions of clause 6.0, clause 6 subsection 2, and clause 33, creates uncertainty and threatens access of patients to existing health cover and their right to obtain their own social security. They said that the definition is problematic. Comprehensive healthcare services makes no direct provision for the progression realization of healthcare by means of benefits. And healthcare service provider, the concern is that the definition of healthcare service provider appears only in clause 1, whereas in the NHI bill, references are made to healthcare providers. In addition, the definition of a healthcare provider differs from the same definition in the NHA, where it is defined as a person registered at a professional council. Clarity is required regarding health service provider, such as community health workers, mid-level workers, and traditional healers. The definition of the National Act is too broad for the purposes of this legislation. In terms of referral, it was said that the definition excludes private establishments, which is against the spirit and intentions of the NHI. On strategic purchasing, it was said that it should include health goods. In addition, clarity is needed on what is meant by active purchasing. The definition is inconsistent with the text of the NHI bill and should be reconsidered. I'll just go back and look at the proposed recommendations within clause 1. A whole host of definitions were proposed that should be included and defined in the bill, including complementary medicine, basic services, which must be clearly defined in terms of the Constitution and international standards. Comprehensive healthcare services, it was said that it doesn't include environmental and municipal health services. There's the use of and definition of the terms for medical devices and IVDs is not consistent, and references to quality should be replaced with good quality. The words reasonable quality should be replaced with phrases that quantify the quality instead of leaving it to be subjective. It was proposed that the term beneficiary replaces the term user throughout the bill. And then the definition for central hospital should refer to public and private hospitals. A health establishment refers to a healthcare practice. It is proposed that healthcare practice should be excluded from the definition of health establishment, as it is included under healthcare service providers. There's a need to define what municipal healthcare services are. The CAPS, contracting units for primary healthcare, and the district health management offices need to be defined. The definition for formulary, as referred to in clause 38, subsection 4, should be defined. A reasonable time period to ensure stakeholder compliance with the provisions of clause 6, subsection 1F should be defined, and the parameters be determined for when to delay in access to healthcare services is unreasonable. A definition for reasonable time period should include to access healthcare services within published timeframes aligned with globally accepted standards. It was said that timely, the term should be defined in terms of specific time periods. I've already, okay, reasonable quality. as set out in clause 11, subsection 1G requires definition. The NHI bill is silent on how reasonable quality will be determined, which raises concern about whether medicine will need to be registered with the South African Health Products Regulatory Authority, SAHPRA. In terms of best practices as set out in clause 11, subsection 1(1) is undefined in the bill, and in terms of how the fund will give effect to developing best practices and to what extent stakeholder participation will be encouraged when the fund develop these practices. Health worker needs to be defined. Medical equipment and health technology should be defined in the bill. Definition for conflict of interest, related party, confidential information should be provided in the bill. And the definition for confidential information should include the term financial interest. Chair, can I ask that I don't go through the proposed amendments because they are already clearly marked for ease of reference, and I'll just focus on the opinions and the proposed recommendations. Thank you.
Agreed.
Thank you. Moving on to clause 2, there were views that the proposed system in the NHI bill will not increase access to healthcare on a progressive basis. Rather, it will deprive many of the access that they currently enjoy. The NHI bill currently contradicts a number of UHC principles as outlined in the 2017 white paper. While the NHI bill successfully addresses fragmentation in financing, it risks further fragmentation across a number of other health system dimensions. Clarity was sought regarding which institutional arrangements are to be put in place on how these will be implemented to support the implementation of the NHI, as significant restructuring and strengthening of the systems are required. On clause 3, clarification is needed as to why the NHI does not apply to members of the State Security Agency, which is clause 3, subsection 2B. While it is understood that the National Defence Force has its own medical service, the rationale for excluding the State Security Agency is not clear. It was said that the laws as the Protection of Information Act 2013 and the Consumer Protection Act of 2008 are constitutional laws and derive their authority from the Constitution. Therefore, the NHI bill cannot override them. And it was said that these laws are excluded from the NHI bill in clause 3, subsection 3. Under clause 3, subsection 5, the bill excludes the Competition Act, and the exclusion of oversight by the Competition Commission could allow for potential abuse of dominance or horizontal collusion. Further, on this particular clause, it was said that the bill provides a possible violation of section 217 of the Constitution, and this could be problematic and would detract from the price negotiation system that will provide flexibility in pricing and adaptability to the needs of specific populations and areas. Furthermore, it is unclear from the bill what the effect of the exclusion of competition principles from the conclusion of transactions under the Act will be and how this will play out in practice. Moving to clause 4, under clause 4, subsection 1E, it was said that the conditions for the users must be clear and adhered to. Clarification is needed as to the specific categories of foreign nationals. Will these include people without documentation, illegal foreigners, etc., and what steps will be taken or followed when these conditions are not met. Furthermore, clarity is needed on what constitutes emergency care for asylum seekers and refugees. That is under clause 4, subsection 2A. Furthermore, what will happen if a refugee or asylum seeker requires assistive devices such as a wheelchair, brace, splint, or communication device? On this particular clause, a lot more was said. Concerns were expressed that taxpayers will be expected to pay, amongst others, for the healthcare services of illegal immigrants and other foreigners and visitors to South Africa. It was said that this particular clause is not supported as taxpayers are already overburdened. The provisions relating to asylum seekers and illegal immigrants will be impossible for doctors to implement. Others said to deny refugees access to only a few healthcare services will not be constitutional, and they should be provided with access to healthcare in the same way and manner as the rest of the population of South Africa. It was further submitted that they should have access to mental health care to assist them with a list of difficulties they may be facing. Others were concerned about the lack of full population coverage and restricted access to healthcare services for asylum seekers and illegal foreigners. They said there are human rights considerations as well as the potential impact on communicable diseases that are not notifiable. The bill's provision of
Ms. Kabali, just give me a moment. Dr. Tembakoyo was called twice. She wants to be let in. She's on an 083 number, and
okay.
I'll put that on the chat. Who is manage hosting? Is it Baldi who's managing it? Or is that also you?
It's supposed to be me, but I also made you co-host chair so that you can assist, because
okay.
Bali was struggling with the network earlier. Thank you, Chair. Can I continue? Okay, I'll just continue.
Yes, please continue.
Okay, thank you. The bill's provision for asylum seekers and
Ek is in 'n vergadering. Ek is nou jammer. Please continue. Sorry, it was a telephone call. Somebody's trying desperately to get hold of me. Please continue.
Okay, thank you. And the last point under that clause, it was that eligibility of foreigners could potentially cause an influx of foreign nationals into the country. This may place a greater burden on the already under-resourced healthcare system. And then under clause 4, subsection 3, it was said that the rights of children to care under the NHI fund must therefore exceed what is set out in the definitions of the NHI bill under healthcare services. It was questioned whether children of asylum seekers and illegal immigrants will gain access to healthcare. The state should extend antenatal and obstetric services to asylum seekers and illegal foreigners. And it was said that it's not clear whether the NHI fund would cover a range of additional essential services for children of asylum seekers and illegal immigrants. Just to back up to the recommendations under clause 4, subsection 1, it was suggested that it should be amended to include the purchasing of healthcare services on behalf of temporary resident and/or visa or payment holder. It will be important at a population level for asylum seekers and illegal foreigners currently in the country to be afforded the same rights as refugees to access healthcare services. It was said that asylum seekers, undocumented migrants, students, including foreign nationals on study visas, and all children should be included as beneficiaries to clause 4, subsection 1. It was also recommended that the government needs to address urgently misinformation regarding the eligibility of foreign nationals as it relates to NHI benefits. And it was proposed that the NHI should work with NGOs and NPOs to assist the healthcare system with concerns related to asylum seekers and illegal foreigners. private medical insurance should be compulsory for all foreigners residing within the country. The NHI bill should include descriptive information on how emergencies should be handled, especially as it relates to specialist intervention. The Council for Medical Schemes should be required to include in its list of acceptable medical schemes, international medical scheme that can be used by foreign nationals, traveling to South Africa. Clause 5, a lot was said around this clause, and it was viewed as restrictive in terms of the registration process and the requirements thereof. It was said that the bill makes no provision for the registration of persons, of aged persons and mentally challenged adults. And clause 5, subsection 1, the NHI bill stipulates that the users of NHI services must register with an accredited provider. If registration is limited to a particular accredited provider, what are the implications for people who move or become ill on holiday or business? Many views were expressed under this particular clause, and it was said that the NHI does not contain a provision expressly stating that membership to the NHI is mandatory. It is not clear how employees who have not registered with the NHI will be managed. There's no need, there was a view that there's no need to register with the NHI if a user is already registered with the Department of Home Affairs identification system, as the NHI is linked to the DHA system. Any person contemplated in clause 4, subsection 1 to 3 should be able to walk into a primary healthcare facility or establishment, and upon identification via the DHA's identification system, receive healthcare. It was said that healthcare is sought when needed, and a user or patient may not have the necessary documents. Registration is merely an administrative obstacle for the public as well as the NHI personnel. And questions were raised on what the implication will be for a person who travels to another province or needed. 5, subsection 2A, whose beds are not registered could result in barriers to access health. And on 5, the requirements to provide proof of residence vulnerable person deny them access to healthcare services. On clause 5, subsection E, questions or person who cannot provide an original birth certificate, and will this affect persons' NHI benefits? And does this imply that a user specific hospital or clinic has to back up recommendations? It was said that clause 5 must be expanded to allow for the registration of user who is on vacation or a geographical area in which they have registered. Those should be added in this regard. Consideration injured employees who are found and treatment or assessment to be eligible will be dealt with. Their inability to get medical access may compromise ability to patient. Under clause 5, subsection 4B, this clause should be an appropriate person with sufficient expertise to perform registration. Regarding the requirement for proof of habitual place of residence, it was said that not all residences have proof of habitual. It is not clear how the registration of the user, the implications of documents as stipulated in this clause should be discussed in the bill. it is recommended that explicit provisions in the bill for how user rotation will be registered in the system and retain their right despite not having document. Moving to 6, it was said that in relation to access to a credit of limited coverage of services and for users who have to travel to other facilities they are meant to access not be or no longer be accredited. There's a lack of transparency as to what is available and hence to prevent the state from withholding standard of care under the available and approving the state's failure to procure and provide appropriate medication and food in a number of hospitals. At clause 6, subsection D, was said that the term unreasonable is not defined in the end, therefore unclear at what circumstances refusal of health services will be or under the health establishment who will be deciding when to refuse access. Injured use treatment, exacerbate their injury and increase the related costs that are borne compensation. Which is sustainable. It was said that is required on who will determine the available when reasonable time period. The child whether a user special limited to consult or mention special obtain in terms of the on clause. If you stressed this clause, it creates duplicate.
Sorry, Chair, if I may.
Undermine.
Chair, I'm not sure if it's just me, but I am losing the presenter's voice quite regularly now.
Same as me, Chair.
All right, let's try again. I see we're also in load shedding here now. So I'm also beginning. I wasn't certain if it's only me. Ms. Gubane, are you having load shedding there now? Let's try again.
Am I audible?
That's better.
Try again, clause 6.0. This is coverage by medical scheme, single payer of NHI. There's implication for the package care services that will or should be offered by providers who's NHI funded.
We're losing quite a bit now. Just speak a bit more into the mic and see if we can hear you better. I know it's load shed. It's probably the connectivity, but maybe if you speak closer to the mic, maybe it'll be better. And honorable members, you have been sent this document. We're trying to follow it as best as we possibly can. Let's try again, Ms. Ngumane. Hello?
Okay. Let's check. Can you hear me now?
Yes, we can hear you, and I think that two things here. The document is being projected. Secondly, you're giving us a synopsis of what is there. I think we should also try to listen in between what you are saying and not necessarily need to hear every word. That's why That's my understanding of my perception of what we are doing. It would also not be correct to want to hear. One must read into what is being said. So please continue.
Okay, Chair, thank you. I'll try to speak closer to the mic. And then I was on the second bullet of clause 6.0, which says that the clause has for the package of by care providers and healthcare providers whose scope might fall benefits package. And the next clause is that there are also views that clause prohibits patients from out of treatment NHI, which is problematic for patients may not be able to fund such care or medical cover. Further on clause the fund retail
Can you hold there for a moment? Let's see if we tell me whether you're having load shedding now.
No, Chair, load shedding. I think it's the net, it's a bit unstable. Can you hear me, Chair?
Better position.
Let me move around. Chair, I'll to switch the Wi-Fi, this maybe the other one will assist.
That's much better, yes. Please continue.
Is it better now?
Yes, let's see. It's better. I hear you better. Let's continue.
Okay. The last part of clause 6.0 was that users of the NHI fund retain the right to seek additional medical funding support from private medical schemes, and not all citizens can afford to contribute to two medical insurance funds. A concern is that the extent of conditions and treatment will be covered under the NHI may not be exhaustive and may leave other conditions uncovered, such as rare diseases. Under clause 1, it was argued that no criteria to guide the benefits advisory committee in making its determination, meaning BAC can determine a package of benefits arbitrarily with no reference to the reality of the healthcare needs of society and what would clinical practice and appropriate treatment would mean. On clause 7, subsection 2D2, the imposition of ways injured employees run the risk of not being refused at all in the event that the primary healthcare provider is of the opinion that referral pathway is not necessary. In certain remote areas, the choice of healthcare service providers may be limited or non-existent, raised on who will develop pathways are efficient and effective. Further, will the referral pathways be specific geographical areas or will there be referral pathways related to the level of care in the health team? On clause 7, subsection 2D3, it states that a user is not entitled to healthcare services purchased by the fund if or she fails to adhere to the prescribed referral pathways. Questions were raised on what mechanisms will be put in place to safeguard patients who are transferred outside the pathways or for specific reasons, and what degree of choice will be available to patients in consultation with the referring doctor. On clause 7, subsection 2F, it was said that the clause centralizes the provision of healthcare by placing the management of all central hospitals under the NDOH. Provinces are at the core phase of delivery of health services and must be given more funds to improve public health care and not less. More points were raised under this particular clause to say that designating a central or tertiary hospital to national administration will negatively affect the district health system, separating the central hospital from the burden of disease within the community. Clarity is sought on how the national government will take control of the decision making that will be allocated to the hospitals on assets that are owned by the provinces. Clarity is needed on clause 7, subsection 2F4 on what is meant by cost centers. Clarity is also needed on clause 7, subsection 3 on how the portability of users will be initiated and who needs to initiate the action of porting a user to a different primary healthcare provider. On clause 7, subsection 4, it is imperative that the element of reasonableness is included in the circumstances where funding of treatment will be refused. This would ensure that the funding for treatment is not refused or on unreasonable grounds. Clause 7, subsection 4C, it was submitted that the formulary and the essential medicine list must be set out on the basis of evidence-based medicine, and drug procurement cannot be based exclusively on the formulary. Just to go back to the recommendation, it is proposed that the framework for referral pathways be reconsidered to allow freedom of choice. Medical necessity must be objectively determinable under clause 7, subsection 4A. The criteria in terms of which health service benefits package must be spelled out in the bill. The state should ensure that patients that are unresponsive to treatment or experience other forms of treatment failure also have access to medicine to address their needs. The formulary should include innovative medicines and a sustainable choice of generics. The EML must ensure that existing access to medicines and molecules in terms of the existing EML prior to the implementation of NHI is not reduced or limited post to the implementation of NHI. Medicines on the EML must be exclusively located, locally manufactured. Hence, a restricted list of products which cannot be imported into the country should form part of the NHI bill. The state procurement of medicines, medical devices, and equipment distribution of medicines to healthcare centers and all services should be set aside for majority Black-owned companies. Moving to clause 8, it was said that clause 8 creates duplicative coverage by medical schemes and undermines the single payer model of NHI. Concern was expressed on the possible violation of the Constitution with the usage of the word must in clause 8, subsection 2, instead of the word may. Further on clause 8, subsection 2, it was said that it's not clear how the clause will be implemented. What controls does the NDOH have over the cost of services provided by private medical schemes for services not covered by the fund? Will the fund be managed from national with representative from province and the districts? And how is the gap between these levels going to be managed? there's a need for clear communication between the levels, between these levels that are part of the NHI bill. And that clause 8, subsection 2B, it was said that the clause will encourage non-adherence to the referral pathways and will create a parallel system by undermining referral pathways. There are views that the BAC will not have the operational presence or reach to implement clause 8, subsection 2.
Can
Yes.
can I just stop you there for a short while? I'm getting so many messages here of people struggling with the connectivity. Can we just take a 5 minutes break to try and sort out some challenges? Mr. Ngubane, it's now 19 minutes past. We'll be back at 25 past.
Thanks, Chair.
Just need to sort some things out with IT, etc. Thanks. We are back, honorable members. Ms. Ngumane, can you, let's hope it's better now. Can you continue?
Thank you, Chair. Let's try again. I'm gonna share my screen. Okay, moving on to clause 8, subsection B. It was said that the clause will encourage non-adherence to the referral pathway and parallel system. They have used that the BAC will not have the operational presence or reach to clause 8, subsection 2C of the bill. And then the current regulatory framework governing medical schemes leaves them vulnerable to anti-selection and will decrease the affordability of medical scheme cover. In terms of, it was also argued that people must be free for healthcare services in whatever manner they choose. There shouldn't be any restrictions and people should not be forced to join medical schemes or take out private insurance. Moving to clause 9, the view was that the NHI fund is planned to be functional during the last phase of the implementation, but it's not clear whether the department is proactive, its plan to begin the process of implementation. The centralization of the functions of the provinces is a concern that it will it infringes on their constitutional mandate. Clarity on the role of the Minister of Finance is sought in this part because it's important to entrench accountability and how the fund will manage better than any other. The recommendation was that the establishment of the fund would require specialized technical skills and adequate time for its capacity to be built and be fully functional. Clause 10, the fund is empowered to issue directives, and then it was said that in terms of the administrative law principles, a regulatory body normally issues directives. The NHI fund is not a regulatory body. There's a view that clause 10, subsection 1G, results in direct market manipulation by government incentive pricing. Clause 10, subsection 1L, the type of accreditation required by suppliers is stated. And it was said that most international well-run healthcare system centralized pooling and decentralized planning, organization, purchase, and running of healthcare services. And the NHI bill proposes the opposite and requires careful evidence-based innovation. In terms of the recommendations, it was said that for the fund to execute functions and powers, there's a need for strong, efficient, and quality operations. The ambit of the NHI fund's powers to issue directives must be set out clearly in the bill. Oversight of the fund must be centralized to an independent body. Compliance with the prevention of duplication, which already exists in terms of accreditation and certification legislation should be ensured. It's proposed that NHI fund accounts to the board instead of the minister. Clause 10, subsection 1, provide a remedial action based on the findings. Moving to clause 11, it was said that the price mechanism implemented in clause 11, subsection 2 is incompatible with the requirements of the KFMA, FA, and undermines the constitution. In terms of clause 11, subsection 1H, it was said that the fund must not be seen as a player and referee in terms of investigating its own complaints. And then it was said that with the white paper, NHI white paper, the performance monitoring unit was included, and it's no longer mentioned in the NHI bill, which is an important it's seen as an important unit. In terms of the recommendation, it was said that it was recommended that the bill should state how clause 11.1D would work, and clause 11.1L should include that the sharing of information should be subject to law, such as the POPI Act, and then the bill should delineate the relationship between the single exit price system created by the Medicines and Related Substances Act, and then complaints against the fund providers, establishments, and suppliers should be investigated in collaboration with law enforcement agents. It is proposed that the procurement processes must be clear and efficient, and reimbursement must be transparent and years. Clause 12, there's a view that clause 12 is inconsistent with KFA, and there's a clear contradiction between clause 12 and that it's that the board is accountable to the minister in paragraph 612. In page 52 of the memorandum states that the board is accountable to Parliament. The accountability of the board to the minister is a concern. No provision is made for the compensation commissioner or representative of the compensation fund to be part of the NHI board. In terms of the recommendations, it was said that it was proposed that the accountability be established that the board should seek the Parliament or any judicial panel. The board should be accountable to the users of the fund. All amendments and decisions taken by the board should be publicly announced, and that consideration should be given to the cost of setting up and running boards and committees, which would be substantial. On clause 33, it said that the minister holds extraordinary powers in the constitution of the board, and then the process to appoint the advisory panel clarified in the, which is clause 13, subsection 3, and clause 13 subsection 5E should be broadened to include personal or professional interest in the fund. Clarity is needed as to who should be shortlisting the candidates for appointment of the board. The NHI is deemed as to become a public enterprise of importance for the country, and as such, the board should be appointed by Parliament and accountable to Parliament as well as to the minister. It is suggested that resignation should be in accordance with recognized standards. Clarity is needed on a potential contradiction in clause 18, subsection 8 and subsection 9 in terms of removal of board members. Dissolving the board on course is the discretion of the minister, and it does be susceptible to political whims. In terms of the recommendations, it is proposed that accountability to establish the board should sit. I've already mentioned this. The board should be accountable to the users of the fund. All amendments should and decisions taken by the board should be publicly announced. And consideration should be given to okay, I've already gone through this. It should the recruitment and appointment of all board members and executive are required to retain the independence of the board and guard against interference. The minister should not have a representative in the board. Accountability should be set for the board, and the public should be allowed to participate in this appointment. The dissolution of the board or removal or resignation should proceed through Parliament. There needs to be an active participation of strategic members of EXCO on the board. And clause 13, subsection 5 should specify that the board members should not have criminal records or convicted for fraud or corruption. in terms of board members should not have previous working history of industries such as the alcohol, tobacco, pharmaceuticals. And then when a position on the board becomes vacant, expiry of the office referred to in subsection 5, the minister may appoint any other committee person who meets the criteria listed to serve for the remainder of the term. It is advisable that the provision included the effect that the removal of the board member should be done only after due inquiry and upon recommendation of the board. Areas of expertise for board members should include large-scale fund management administration, amongst others, to ensure transparent governance. A clause allowing for transparency regarding the dissolution of the board should be included. Further, on the dissolution of the body, said that Parliament should play a role in that decision in carrying out that mandate. And the Office of Health and Compliance and how it fits in the board was questioned. It was said that the board should be in control of the biggest budgets, and they should be dedicated, experienced, and qualified by board members to exercise proper control. On clause 14, there are views that this clause is against the principle of democracy enshrined in the Constitution. It was said that clause 14, subsection 1 should prevent the minister from appointing the members of the board who represents him or her from acting as chairperson. In terms of the recommendation, the board should be appointed by the board and not the minister should appoint the vice chairperson. The bill should state the powers and functions of the chairperson, deputy chairperson, as well as powers and functions of individual members. The chairperson should be elected at the first sitting of the board. A definitive term of appointment of the board should be specified. In terms of the powers of the board, the requirements for board members are vague. Clause 15, subsection 3C states that the board must advise on comprehensive healthcare services to be funded through the BAC, and it was said that sufficient expertise should be on the board to ensure that this is possible. The powers of the board are not comprehensive enough. It must play a leadership and strategic role. It is submitted that there is an overlap between the functions of the board in clause 15, subsection 3 and the functions of the NHC in terms of the NHA causing confusion. There should be a separation between political and operational spheres, as this may weaken the role of the board. In terms of the recommendation, the board should meet every 6 months to share information, and the bill should set out how the board will function in terms of a quorum required to make binding decisions. The functions of and duties contemplated in the King Code of Corporate Governance should be included in the functions and powers of the board. It is recommended that each board should serve a minimum of 3 terms to promote continuity. The remuneration and conditions of service of board members should clearly be stipulated. On clause 15, subsection 3, the board members should be selected so that they are able to function. Clarity is needed as to the meaning of the term collective bargaining in clause 15, subsection 3F. Clause 16, it does not make provision to compel board members to any interest that may conflict with their performance. Clause 16, subsection 1 is framed narrowly to protect the funds sufficiently. So only provides for the prevention of direct material interest of a monetary nature. Under clause 16, subsection 3, there are views that this should include direct material interest to avoid restructuring of financial interest. In terms of the recommendations, clauses 16, subsection 1 and 2, carefully constructed corruption and structure. Clause 16, subsection 1 should be drafted to include any direct or indirect interest. Subsection clause 16, subsection 3 should be amended to include interest that it should not be confined to monetary interest. Clause 17, a unique and unconventional corporate governance feature that the board must determine its own procedures in consultation with the minister. All these ministerial interaction and consultation requirements in terms of governance and accountability. Clause 18, the remuneration and conditions of service of board members should be clearly stipulated, and it is recommended that the independent commission for the remuneration of office bearers determine the remuneration of the board members. Clause 19 says that subsection 1, that a transparent and competitive process will be undertaken appoint the CEO. However, subsection 3 then goes on to indicate that must be made by the minister who must approve the recommendations of the board. This represents potential conflict of interest. Clause 90, subsection 2 is that the board, which is appointed by the minister, will conduct interviews, and that the minister will approve the recommendation of the board. This also represents potential conflict of interest. It's unclear who is empowered to remove this. Powers of the CEO to deal with the financial affairs of the fund are akin to kind of powers the PFMA entrusts to accounting authority, the accounting authority of an entity. It was recommended that the board must appoint the CEO and other executives, and the eligibility criteria or the list extended to the appointment of the CEO. The CEO must complete the performance agreement with the board. The bill must state that the CEO should be subjected to judiciary duties akin to those provided for in and of the FMA. Clause 20, in particular, clause 20, subsection 2E, while it is notable that the NHI makes provision for powers in terms of corruption and maladministration within the fund, it is concerning that it does not occur to any body. Other stakeholders do not support the creation of the unit. And then it is recommended that the bill that those 20 subsection 2 should be aligned with subsection 3I to ensure that there are no different unit function. It is essential that the unit to be established functions independently. Clause 20 subsection 3 appears to overlap with the rules of the health product procurement contemplated in clause 38. There's a need for clear role definition between different committees and some units to be established by the CEO. And then clause 21, the reporting line in clause 21 of the NHI between executive authorities and the administration expressed more clearly. It is argued that the notion expressed in clause 21 subsection 2 is highly unlikely when there is a clause in the bill that states that the board will forward their recommendations to the minister for approval. There was no input under clause 22, clause 23. It was said that in terms of the committees, given the extensive jurisprudence and recommendations by the King's report, it would have been expected of the NHI to propose an audit enumeration committee and perhaps a patient interest of similar committee with powers to co-opt independent members. Due to governance concern, board members should not serve on committees. Clarity should provide to members membership of this committee. The board and not the in terms of the recommendation, it was recommended that the board and not the minister should establish all in this section. The governance framework must comply with the King Code of Corporate Governance. The committee should appoint a chairperson from among its members. Not the size of the committees must be specified in the bill, and the requirements of this committee should align and routine. On clause 24, it was said that it's unclear what technical committees mean and what functions will they fulfill. There are concerns that the NHIP does not allow the from private sector, the composition of the board. The requirements for the technical committees are vague. It is not clear if the technical committees are comprised of members of the board, and it should be stated whether additional expertise can be brought in or an expert can be co-opted into the committee. It was said that there is insufficient provision for the sizes, appointment processes and mandates of the various committees of the bill. The bill should allow private sector expertise in the composition of the committees. There are views that there is an overlap between the task of the committee and the action plan arising from the provincial health compact. Academia should be in technical committees. The eligibility criteria of persons to serve as members of this committee should be strengthened, and the NHI should set out a framework for the establishment and composition of each of these committees, and include issues such as the terms of appointment, procedure appointment, amongst others. Clause 25, the bill does not adequately set out the appointment process, terms, powers, and functions of the advisory committee that will be supporting the fund. The minister should not be allowed to establish committees with independent powers that are imposed on the board. On clause 25, subsection 5, does not include private health establishments, and there's no provision made for the representation of professional bodies or statutory bodies such as the Health Professionals Council. In terms of the recommendation, it was said that clause 25, subsection 2, the membership of the BC should include technical expertise in nursing and pharmacy. The benefits package should not diminish, and the range of medicinal molecules currently available and allow for a wide choice of medicine. There must be a clear correlation between the recommendation of the BAC affordability and budget, because at this juncture will be disastrous. The minimum requirement should address a number of persons comprising the committee appointment, terms of appointment, fitness of persons, amongst others. It is recommended that the board be responsible for appointing members. The requirements of the members must fit the responsibilities of this committee. It should be stated whether additional expertise is brought in. If outside members to be appointed, and the appointment criteria similar to those of the board members, it is recommended that the benefits advisory committee and the healthcare benefits pricing committee include at least 2 representatives from organized labor and civil society. Members of the BAC should be elected from professional bodies guided by the principles of evidence-based medicine treatment. On clause 5, subsection 5, the treatment guidelines and protocol must be evidence-based and must be gazetted. Clause 25, subsection 5C, the committee should only recommend to the board. It is proposed that the independent of the NHI, operate under the auspices of the independent supply regulator. Clause 26. It is not clear how this committee will function, how services can be organized. Also, international practice provides that the committee clearly defined in terms of their function as set out and who are charged with the overall management of the fund. Clause 26, subsection 2 omits some key areas of expertise required of such functions. It is recommended that the rules and consultation
Hold on, please. Who is that? Can you see who's it is? Ms. Wilson, Honorable Wilson, Honorable Munia, please close your mics. Thank you. Honorable members, I am also running very low here on battery power, both on my phone and on my laptop. Oh yeah, it's going to shut me down. If I am shut down, Honorable Munia, I must please continue with the meeting. Can you hear me? I'm going to be shut down any minute. Even my backup
I
doesn't.
can hear you, Honorable Chair.
Thank you. Thank
Let's
you.
proceed.
Please continue, Honorable Munia.
Let's proceed, please.
Okay, thank you. And on the last recommendation under clause 26, that it is recommended that the required areas of expertise be expanded to provide for expertise in coding, costing of healthcare, pricing of private sector, amongst others. Clause 27, they were said that the clause lists all stakeholders other than the functions of the committee are not clear, particularly how they impact processes of decision making. It is not clear to whom the stakeholder advisory committee will be accountable. In terms of the recommendation, it was said that the clause must be amended to as a stakeholder to this particular committee. It is recommended that brokers or financial advisory structures form part of the listed stakeholder group on this committee, supply chain management experts, and that the role of the stakeholder advisors will be clarified and process should be within the remit of the committee. On clause 28, it is proposed that all committees must function as the processes board. Clause 29, it is proposed that the board must determine these by notice in the Gazette. Clause 30, the bill should include a clause that reflects the disqualification criteria as well as the provision for conflict of interest. That provision is made for members. On clause 31, a lot was said under particular clause. In the main, there were views that the minister has been afforded wide powers to regulate and issue significant operation of the fund without sufficient guidance from Parliament. As many were expressed, I would just touch on a few without going on repetition, because most the views were, there was a common expressed view under this clause. And clause 31, subsection 1, it speaks to the granting of excess powers to the minister and affect decision making. Clause 31, subsection 1, the responsibility and governance stewardship should lie within the board. And there's a need to streamline the NHI management to meet overlapping role. Bureaucratic control will stifle and innovation and promote corruption, adding to overall cost. Two powers of the fund and the minister is concerning that certain regulations will be published and finalized without public comment, and that binding directives can be issued by the fund. The autonomy of the fund was raised that the powers of the minister are heavily concentrated toward the structure of the fund. Appointees to the board, it was said that too much powers are granted by clause 13, subsection 1, 8, subsection 1, 3, 8, and 9, and that there are no mechanisms in place to ensure that the minister will not appoint their own party's preferences. The autonomous powers conferred on the minister to appoint and remove the board members, the concern. The sole appointer of the board, the minister is the sole appointer of the board, leaves him or her vulnerable to current employment. There's a concern with both the appointment of the board and the reporting lines. There are no mechanisms in place to ensure that the minister is not vulnerable to potential political influence. Most of the submissions said they do not support the extensive role of the minister as set out in the bill. The power to potentially veto every significant decision that the board can make. The board must be free to appoint and terminate services of the CEO at facility level where central hospitals will become semi-autonomous entities and appropriate governance as a it is necessary to develop a new mechanism to the appointment of board members for the child fund. The minister has afforded wide powers to regulate on each significant fund. Adequate governance framework and strengthening accountability mechanisms across the different stakeholders are required. In terms of the recommendations, many recommendations were put forward, basically to say that the governance of the fund must be centralized and inclusive to ensure transparency and accountability. The roles to be expressed in the bill for other stakeholders. The appointment of the board, a decentralized approach is required, the involvement of more stakeholders. Powers must be diffused from minister to include the role of stakeholders. The proposed ministerial advisory committees must be convicted into the board. The accountability mechanism of the NHI must be defined. Parliament should conduct interviews and recommend names of board members. The NHI should include better mechanisms for accountability and oversight, which are legislated. There's the need to be clear in terms of the powers, roles, and capacities of board committees in relation to the board minister. Minister's oversight should be counterbalanced by other authorities. The fund should be accountable to Parliament. The board must be able to determine benefits covered by the fund without prior approval of the minister. Clarity is needed as to funding of advisory committee. Powers of the minister should be centralized. These powers should be centralized in the board of or the judiciary set out in the accounting authority. Good governance requires legal frameworks that are enforced by impartial for the full protection of stakeholders. It is proposed that clause 31 subsection 1 provides that the minister and province are co-stewards of health. Moving to clause 32, it was said that clause 32 subsection 1c does not mention healthcare services rendered by districts, municipalities. It is unclear whether this is referring to municipal health services. In clause 32 subsection 2a, it is unclear what provinces are management agent of. and the views that province stewardship. Those 32 subsection and who have oversight of the hospitals as those 2 subsection 2C that the minister established all as government components, the role of provinces once again clear. The recommendation that non-personal healthcare services mentioned under clause 32 subsection 2C should be clearly spelled out to remove clause 33, the many expressed under this clause mainly highlighting as uncertainties on as to how medical schemes will be phased out or should they be phased out. The concerns as to what would happen to medical schemes, and as most patients will not be able to afford medical scheme contribution. The complementary nature of the NHI and the medical scheme benefit clarify in line with the Medical Schemes Act Amendment Bill that it is needed regarding the benefits medical schemes cover. It will be critical to ensure that complementary services of medical schemes do not encompass essential population needs that limit the fund's capacity to achieve equity, access, and ultimately see there's a lack of clarity on the rules of the fund, medical and private insurance. The bill should provide for purchase complementary health services benefits that are not covered the fund through the voluntary medical insurance. The prohibition of medical schemes to provide cover in parallel to the NHI and by the NHI for that is national standardization of care through procurement and national pathways will lead to potentially being reduced. Some patients limiting the role of medical aid scheme will not be sustainable. Submissions were opposed to the prohibition limitations on private medical scheme cover for services rendered by the NHI. The key assumption is that medical members will be willing to switch from healthcare provider via the private sector and finance medical scheme to healthcare provided by the NHI. For NHI to work, there's a need for a single purchaser model where the government is the only institution that can buy services. There are fewer details around the role of the medical aid presented in comparison to the white paper. Clause 33 refers to the role of medical scheme, but there is no reference in the check to other funders of healthcare. In its current form, clause 33 probably constitutes unconstitutional improvement of the right of healthcare as contemplated in the Constitution. It will be substantially useful to use the establishment of the NHI as an opportunity to improve the way medical schemes function. The prohibition of medical scheme to provide cover is parallel to the NHI will limit patient access to healthcare. It is unclear to what extent the medical aid related services currently available under COIDA regime will be available at the NHI. The recommendation is that the medical schemes should be allowed to continue to offer the same cover by the NHI fund. A gradual phase of the medical scheme tax base is recommended. This clause should be amended so that it does not deal with complementary services. Clarification is the monitoring of all the establishment and practitioners who provide healthcare services. Private medical scheme schemes should coexist with the public sector. It is recommended that
Sorry, I didn't hear you. I heard you saying private medical scheme. Can you repeat that, please?
yes, the private medical scheme should coexist with the public sector to deliver UHC. I will find,
You may proceed. You may proceed.
Thank you. It is recommended that the impact of reducing the role of medical aid to complementary cover in the NHI be assessed from a legal perspective. The health service benefits and formulary under the NHI should take into account the medical and related benefits from that are provided under COIDA. There were calls for the publication of draft regulations to be expedited for stakeholders to have a clear understanding of the legal framework. Clause 34 it was submitted that the record keeping processes for continuity of care are required. And currently, there are many challenges: data collection, record keeping of information, data management in the health system is fragmented. Healthcare workers have limited access to computers at the rural level. Therefore, it is unclear how the system is implemented without the required infrastructure. Clinical information in most public hospitals that are not electronic is a challenge. The NHI does not provide guidance on the biometric system required or the coverage required of the IT system. There's a lack of specificity regarding the extent of development and the lack of recognition that the current constraints to the data collection as a result of staffing shortage, particularly at primary care level. The NHI, the National Health Information System in clause 34, subsection 3 must be strengthened to ensure that in addition to the provisions of the NHI, must also comply with the requirements of this act. The system developed should be an intelligent digital healthcare system that is compatible with the various platforms in current use by practitioners. In terms of the recommendations, there's a need to create a national information system to ensure that everybody is enrolled in the system at the initial stage. The NHI fund should ring-fence the budget for this purpose and appoint a highly professional team to ensure the design and maintenance of the healthcare workers and providers and people in charge of establishment comply with the provisions of the NHA to ensure that information is provided and done in a standardized electronic format. The patient registration system aligned with the National Health Information System. Clause 35, subsection 1 states that the fund must purchase health services in accordance with need. The phrase gives rise to concern what they need to, and not according to the benefit covers. Strategic purchasing, there are no provisions that define the concept or describe how it is implemented or undertaken by the fund. Further on clause 35, subsection 2, it was said that facilities did not receive accreditation due to factors related to funding or support. What will the funding or financing arrangement to ensure that these facilities can be approved with accreditation? There's a concern about the impact of aid diagnosis groups funding model as it takes into account outpatient expenses. The reimbursement strategy must consider the total cost of providing the service, in particular in the private sector, for all, because the health providers are responsible for all the overheads, including pages and hiring of staff. Hence, the reimbursement must be sufficient to cover this overhead. In terms of the recommendation, the provisions regarding purchasing and the roles of the district health management offices and the contracting units for primary health care and the relationship are intricate and need to be elaborated with the lines of reporting and accountability. The strategic purchasing model needs to be clarified as it is not clear on the basis of it. Clause 35, subsection two, clarity is required on the position of private hospitals and private medical specialists, as well as other practitioners not part of the CAPS. Further on clause 35, subsection 2, it was said that this clause should be removed as it has the potential to benefit the private sector. Currently, there is no diagnosis-related group in public health sector. Hospitals are one-stop shops for every. Under clause 35(4)(a), it is suggested that the remuneration mechanism not be predetermined but left to the price committee and the board to determine. Clause 35, subsection 4(a) must be amended. There's a need to improve government services instead of private owned companies. Clause 35(4)(a), the definition for kept space, as well as what this comprises. On clause 35, subsection 4(a), that disputers create disparities and do not strengthen government resources. The provision should be made for consideration of small and medium-sized suppliers for procurement when they do not have capability. The procurement process must be effective. Suppliers must be reimbursed. Because 36, the NHI does not explain the reason why the HMOs and CAPS does not set out their role and how they are governed, they be accountable. There are concerns that the HMO's capacity to oversee mental health care in the primary health care settings, especially in the primary health care system central role, federal government-based financing, such as targets for personal preventive services must be included. Submitted that this doesn't align with the proposed amendments to the NHA. This is an area of strategic importance, as this is where the current public sector primary health care system starts to engage with GPs, the private sector, hence requires wide consultation. There's a concern that with the relevance of this structure, as it will add another layer of expenditure to bureaucracies of service delivery. Concerning clause 36 and 37, it argued that the insertion in the NHA is in conflict with the substantive provisions of the NHI. In terms of the recommendation, the DHMOs and CAPS are unnecessary and add layers of administrative costs to the system. The mandate of the district health system should be extended to manage district clinical specialist team, performance-based I'm a bit lost. Which could consider the inclusion of a minimum of psychiatrists, occupational therapists, psychologists, etc. Clause 37. In instances where primary health care is provided by local government, it is not clear whether the CAPS would contract services individual or via the provincial administration. The bill is generally silent on the role of the private sector with regard to CAPS. It is suggested that the CAPS function establishment are dealt under the proposed amendments of the NHA bill. Clause 37 revised to introduce a phased process for the creation of the CAPS once cooperative government milestones are milestones are reached. Clause 37, subsection 2D needs to be expanded to deal with suppliers of food as well as inclusion of the PFMA. Clause 38 deals with the Office of Health Products Procurement. It reviews that the functions of this office overlaps heavily with those of SAPRA in terms of the processes of development and standard treatment guidelines, requirements of related products. terms of clause 38, subsection 1, clarity requested on whether the current office of Chief Procurement Office will be absorbed to this office. The scope and ambit of clause 38, subsection 3 is currently unclear with regards to benefits to be provided by the fund. Clause 38, subsection 3B, clarity is needed as to how and when and against what criteria this list will be developed. Consultation is needed. Clause 38, subsection 3, product choice will according to the preference of the end user. Clause 38, subsection 3H, what will qualify as a high cost device is not be included in the product list as per clause 38. Clause 38, subsection 4, the Office of the Health Products must support the Benefits Advisory Committee in the development and maintenance of the formulary. If the provisions of clause 38.4 are adopted, many patients who currently have access to the non-EML and non-tender medicine, the public sector no longer have access to these. Clause 38, subsection 5, the office must support the report annually or regularly. There seems to be no option for procuring outside the formulary, whereby clause 38, subsection 6 knows that the formulary includes supplies. Procurement in the public sector is currently managed and controlled by National Treasury. It is not clear how the proposed procurement system will be aligned with the existing processes and systems in view of the establishment of this office. The question was raised on whether there's going to be some regulation of cost for health services, and then that healthcare should be commercialized. On clause 38 and clause 38, subsection 2, there seems to be a contradiction of health-related products, which expressly exclude orthodox medicine. A new separate office outline is inappropriate and wasteful and therefore not required. There were also views that the NHI bill is contradictory in terms of how it set prices, negotiate prices. Some views do not support a price setting system, but would support a negotiation system. The roles and powers of the office with respect to price setting and procurement of medicine is clarity. The provision relating to pricing and payments are fundamental cause in various parts of the uncertainty as to what the future holds for patient access to products. The role of the health establishment, the office of the product procurement, decision, ordering and supply are not changing. Although the bill provides more insight into how health services will be at different levels, it contains no specific details on how the technology will be procured. The roles and function of public depots in the nature system is not clear. An additional complication that would lead to increasing medicine supply, the obligation placed on successful leaders to contribute to the national industrial program. There is no guarantee that monopoly buying power will increase prices from healthcare providers. There appears to be conflict between the contemplated mechanism for a pricing of medicine. Furthermore, the unforeseen effect to medicine pricing is not covered by the fund. It is submitted that in NHI memorandum are in conflict regarding the establishment of the OHP. Just to back up to the recommendation, it was said that there's no need to consult the minister to discharge a function the board is responsible, which is in clause 38 subsection 1. It was further suggested that clause 38 subsection 4 must be drafted to ensure that medicines available in the NHI cannot be excluded. What is not on clause 38 subsection 4 should state that the function of the office is to develop and maintain and it is responsible for the review of the list, including the development in new technology. It suggested that those 38 subsection should be aligned with those 38 subsection 13. Where treatments are not approved on the NHI accredited facilities, the ability to control according. There is a need for alignment of procurement between the responsible parties as for consumables are not interchangeable. Clause 39, it was said that the accreditation of facilities funded by the NHI is not clear. There are concerns about the licensing requirements of facilities and providers of care. There are concerns that the proposed accreditation approach appears to force providers to choose to contract with the NHI entirely or spread on, given the state of many rural facilities which are characterized by infrastructure decay and understaffing. There's a risk that many rural facilities will take a long time to meet the accreditation criteria. There is a concern that the accreditation process would render the majority of public sector facilities eligible to be contracted by the fund. That is on the pages of the accreditation of service providers. The NHI bill provides for accreditation and contracting of suppliers. However, there's no indication of what the accreditation requirement process and road of accreditation for suppliers. The definition of accredited one or the bill refers to clause 39, which is only applicable to service providers. Accreditation of suppliers should be relevant and provide, amongst others, for the range of products offered by the different suppliers. There's no mention of private providers of environmental health or municipal health services. Clause 39, subsection 4 will be prescribed minimum or maximum volume to the duration containing the contract, and whether and what does volume entail. Clarity is required on what is meant by performance expectation. Clause 39, subsection 4. And clause 39, subsection 5, it was said that this section will be appropriate in clause 34, which is the National Health Information System. While the NHI states clause 39, subsection 7, that the fund must review the accreditation of service providers under every 5 years on the basis of compliance with the accreditation criteria, does not state whether facility is not accredited at the time of purchasing to reply or accreditation at a later period. Accreditation by the OHS introduced the risk of creating an open market as the concern of that if relatively facilities achieve accreditation, the nature will result in privatization of health system. There's an assumption that there are adequate service providers. However, that those service providers will be accredited to provide. There are no contingent plans in place should this not be the case. Of particular concern will be the small rural towns where facilities may not be adequately managed. It is important that the requirements to obtain the certificate of needs are clear and discussed with parties. It is submitted that if certification is required for accreditation, currently 0.7% of public health establishments are certified compliant, then the timeline set for implementation of the NHI is unrealistic. Further detail is required on how quality assessment or control of services provided by each establishment will be conducted and how participating facilities will be reimbursed. There is no reflection on the need to strengthen primary services to be accredited for contracting. terms of the recommendation, it was suggested that those included include the services rendered by medical specialists and other practitioners, allied professionals. It further recommended that the public health facilities be assisted to gain accreditation in the process to counter the potential monopoly power in providers. The term must contain a subsection explaining the implications of the way accreditation is obtained by the provider or establishment. The accreditation process should not be duplicated by the OHS. The process of upgrading or improving non-compliant facilities be provided or bring to ensure that people's rights to access health care services. Efforts should be made to strengthen the public capacity to meet accreditation standards. The process for accreditation should not be a barrier to the provision of quality health care. Cautions that there may be duplication of functions by the proposed fund, the HMOs, caps, the accreditation of service providers. In clause 39, subsection 2B, it is suggested that publication of the required range of services will result in flexible contracting. Clause 39, subsection 2B3, it is suggested that other provisions refer to treatment guidelines, whereas here treatment protocol guidelines, it is requested that the system terminology. It is recommended that the fund should also contract directly with primary health providers other than through CAPS. In clause 39, subsection S, H, it is recommended that the information submitted should not change frequently with resource and communication. Clause 9, subsection 8C, to allow for geographical limitation or area of specialization or specific establishment, the provision should amend to allow exclusion. 9, subsection 8K, that it is required on what code of health related ethics or the relevant law refers to. Clause 40, the NHI elaborates addresses the importance of a national for the of the fund, but it does not how it will interface with the Home Affairs Information System and how the data from the fund will be accessible for prospective. Given the already burdensome regulatory requirements on healthcare professional care should be taken, and that the NHI and the medical amendment do not create additional layers of regulatory compliance. Medical schools already collect information rather than the NHI create its own database. It might be advisable to rather obtain an exemption from and allow members to share with the NHI and say for medical scheme. Where there is proper sharing of information, patient data, subject to the protection of medical information, there would be a greater opportunity to render more efficient and healthcare services with enhanced patient care. It is recommended that clause 40 subsection 2 be aligned with the information submission requirements set out in subsection 39, in clause 39, subsection 5. The provision for personal information by third parties must be private, such as private makers of the Copy Act. It is submitted that information architecture specifically refers to the structural design of shared information environment and specifically to the organizing and labeling of information. It does not relate to fraud and mismanagement and therefore cannot act as a preventive mechanism. Hence, it should be rewritten with the appropriate from professionals. Those 40 subsection 5 provide clarity on the fraud and risk management mechanism. All hospitals must be equipped with the health technology, information technology needed to connect to other hospitals across the country. Clause 41 states that the NHI, in consultation with the minister, will determine the nature and mechanism of provider payment. While clause 20, subsection 3 places the function of setting up a unit of providing payment in the jurisdiction of the CEO. The view is that this is of discretion of the fund. That it is requested on what is meant by additional mechanisms. Clause 41, subsection 1. And the NHI fund provides no information about the application of supplies required in clause 41, subsection 2. Clause 41, subsection 3 is unclear, not aligned with other related provisions. It is submitted that the law of contract applies if what legislative clause 41, subsection 4 provides. There is uncertainty relating to how service providers will be compensated and how private practice would fit into the implementation of the NHI. The lack of clarity on the payment of providers is concerning, with limited information available on what conditions are prevalent. Different facilities, not clear how the costing is done and reimbursement calculated. It is suggested that the requirement the NHI under clause 11 that the fund must negotiate the lowest possible prices for goods and healthcare services is removed. The provision for occupational therapy often overlooked, while the full recovery of the patient often requires occupational therapy, without which the patient will progress to relapse, which actually cause the health system or most of the reimbursement functions under the NHI and envisaged to function based on the reimbursement contracts signed between the NHI and providers. Clarity is required on the proposed amendments to the route to the fund COIDA as it affect the provision of occupational therapy services COIDA and REF. It says provide service users lack information on what services funded. It proposed that all NHI benefits set out on the principles of evidence-based practice and not medical necessity. The tariffs set by the NHI fund on in terms of the NHI must take into account the realistic and reasonable cost incurred by the healthcare providers in rendering the service. In terms of the recommendations, it was said that the proposed amendments to the NHA not provide for caps to have contracting functions, hence as we the fund to contract as primary care provider. Under clause 41, subsection 5, it is recommended that subsection 5 be deleted. The relevant definitions included in clause 1 of the NHI. It is proposed that they provide clarity on the of all inclusive regarding the recourse for non-payment. It is proposed that timeframes be established by references to health insurance in the NHI should distinguish between insurance products and medical schemes. The capitation versus the full service model of reinvestment needs to be balanced with a hybrid to counter the effects of patients. Establishments and providers should autonomously determine ancillaries that go into the provision of service. Clause 42, the question was raised on how the process is described in two releases in the general rule. The fund cannot would manage funds and deal with complaints regarding the management of the fund. This should be done by an external party. The governing of the funds should be regulated in complaints and appeals. There's a significant scope for broker services. Further, the type presents a long winded complaints procedure that to appreciate the magnitude of the grievance on the life of the complainant or the affected. The proposed recommendation that centralizing the complaint function is considered impractical. Clause 42 to be drafted because it allows any child to complain against it is recommended that clause 42 subsection 3 be amended to provide for complaint in the form of the outcomes as it may adversely affect complainants. The bill must provide a veritable and user-centered complaints procedure. It is recommended that the complaints process be distinct from the CEO so that the forum be independent from the fund, and be empowered to deal with it. The structures should be in place to ensure smooth processes that would things as well as proactive approaches that will minimize the complaints. The complaints process and timeliness should be for clarity and transparency. Under clause 43, the wording under clause 43 must be broader to cover all relevant persons. It is suggested that the persons involved in the complaint should be able to appeal a decision. Clause 44, under clause 44, subsection 1A, they was said that this may be misinterpreted as chairperson of board of the NHI fund. And the concerns that there is a significant potential interest in that the process run outlook. In terms of the recommendation, the appeal tribunal should be independent of the board to ensure the credibility of the board. It is argued that a 3-year term is too short. 5-year term is rather proposed. The provision to co-opt relevant depending on the complaint. Provision should be made for disqualification, determination of membership. The appeal tribunal should consider the strategy to deal with complaints. The NHI should provision better eligibility should provide for the quorum requirements to the extent that the decision by the tribunal should be chairperson and 2 other members. Clause 45, the inclusion of the clause that refers to the rights of appearing before the tribunal is proposed. Clarity is requested as to whether the appeal tribunal can make post orders. It is recommended that parties appearing before the tribunal should have the same rights as they would in the High Court, for example, have a legal representation. Hence, a clause should be providing for this right. Clause 46, it is submitted that the tribunal have its own staff and an infrastructure to the decision referred to it, and also the tribunal and the board. It is recommended that clause 46 be aligned with 47 in respect of record keeping. Clause 47, subsection 3 provides that the appeal tribunal must determine the outcome of appeal within 180 days. We must say that 180 days is excessive and propose that the appeal should be completed in 90 days. Clause 47, subsection 3 should align with clause 56 in respect of record keeping. And then clause 48, the next two clauses receive many expressed in terms with regard to the financing of the NHI, raising concerns about the absence of the health finance policy. Starting off with clause 48, it was said that the legality of clause 48, subsection B, is questioned, and as all income must be paid to the National Revenue Fund. Excuse me. While a mandatory prepayment system is mentioned in the NHIP as a source of funding, it is not clear how this will be operationalized. The NHIP does not provide reliable cost estimates for NHI, nor does it offer a clear picture on what the impact will be on taxpayers. There are shortcomings in the NHIP, and it is submitted that the draft regulation dealing with the budget of the fund should have accompanied the bill for comments and submissions. There is agreement with the source of funding stipulated in the bill. I believe that if we're going to have quality healthcare, someone needs to pay for it. It remains unclear what the total cost of the NHI, the proposed tax on employers will place burden on the tax burden on the children tax base. That is on in the form of a treasury as required and proposed funding NHI. In terms of the recommendation, was that clause 48 subsection C be deleted as a consequential amendment that the fund may be allowed to fund. This proposal that no information is provided to confirm the sustainability of the proposed NHI reforms. A solid funding plan should be put in place prior to the implementation of the NHI. Clause 49 in relation to mandatory payment and chief also income, the scope and meaning of and the connection between such connection has been verified. The specific around the funding of the NHI is from chapter 10 of the NHI is silent on the system's overall likely cost. No accurate costing was done. There is no indication of financial viability of the NHI covering budget, fund reserves, and fund investment. The entire funding mechanism potential oversight on solving issues of the scheme requires clarity. In terms of the recommendations, without an accompanying money be difficult to determine how resources will be sourced and what the impact will be. Clause 49, subsection 2, A2, the funding for medical to various medical schemes untouched. Clause 49.2 should be dedicated financial plan with guidance. Two other models were proposed: the voucher system or the value system capitation, which the voucher system essentially work the way as medical aid work, and the capitation will providers are paid a prospective or cap per member per month fee. Clause 50, an oversight function beyond the Auditor General should establish to monitor the activities and finances of the fund. Clause 51, it is recommended that a report on health outcomes as per the health market inquiry included. Clause 51, subsection 3 should be specified in the bill that the financial institution must have a specific international rating to ensure that not any institution is used. Clause 51, subsection 3, it is recommended that this be an independent actuary to allow for information integrity. Clause 52 circumvents the board of the fund by allowing the minister or the CFO to assign any other duty, any of their duties or delegates any of their power to any fund. There was no input. Clause 54 and the clause 54 subsection 2, the issue of directives by the fund is not supported. The recommendation that the extent in the environment should be limited within the fund, but rather determined in line with the spirit of the offense. That is clause 54, subsection 1. The 100,000 fine for corruption was said to be too soft and harsher punishment. The should be set out, which is clause 54, subsection 1. Clause 55, clarity is required as to the necessity of clause 5, subsection 1, when clause 41, subsection 1 provides for payment. It's recommended that there is a need to be more inclusive to ensure appropriate engagement from stakeholders. Clause 5, subsection 1, involvement of and contribution of traditional leaders should be included under this subsection. Clause 55, subsection 1I and J, it is suggested that this subsection be deleted because these are covered in the amendments to the NHA. Clause 55, subsection 1 and 2, it's recommended that the entire complaints and appeals procedure be included in the Clause 55, subsection 1, clarity sought or as to what fees are in stage of collection. Clause 55, 1X, suggested that the various subsections dealing with funding or payment of services be combined or aligned. Thus, clause 55, subsection 1Y, it is recommended that committees should function according to charters, the code of conduct, separate item. In relation to clause 55, submitting notices of change to the Gazette for a fund that runs on a massive IT and the process of obtaining feedback. Clause 56, clarity sought on the scope of applicability of the directives that the NHI fund issue. The recommendation is that clause 56, 1 deleted. They have viewed that it is not acceptable for the fund to issue directives that are binding to the unilateral administrative and does not provide Clause 56, subsection 1 and 2, the issuing of directives by the fund is supported. It is recommended that the fund they make directives for the purposes of implementation and administration of the fund. Clause 57 provides for part of the period that has already passed. It does implies that all actions taken in view of giving effect to the transition arrangement will amount to that way once the bill is enacted. Clarity is requested in clause 57, subsection 3 on when committees to exist and how they will be established, what their functions will be. Clause 57, subsection 3, the role of private medical schools or private training platforms and payment for training as part of service delivery needs to be clarified. The NHI bill does not include HTA. Further details provided to describe the scope, function, of the levels of autonomy of the NEC on HTA. There's no information provided on the composition and decision-making processes of the committee of this committee. It is critical that the multi-stakeholder forum, the approach to drive cost effectiveness as laid out in sections of the bill is the pragmatic one, but must not be treated as often lowest cost is not the best way. In terms of the recommendations, it was proposed that clauses 57, subsection 1A and 57, subsection 2 be deleted as they do not speak to the implementation of the Act. Clause 57, subsection 4, 3, consideration should be given to the increase of services and developing requirements of primary health care. Down NHI should be considered and should form part of the transitional period. The subsection should mean physical disability. Clause 7, subsection 4F should include registered psychologists in the list of designated providers. The NHI should include a definition for HTA that recommends establishment of the HTA. EDA proposes that more detailed description of the task and stakeholder representation provided for the HTA. The terms of reference for the MEC should be published by the committee, should not be housed within the fund, it should function independently. It is proposed that a wider framework other than just the HTA as value assessments are not outcomes in themselves. Further on the HTA process based on the principle should review regularly. It is proposed that of international international markets, which is the procurement of technique and the take open-ended phrase where necessary or required should be considered. Clause 58, which is the NHI proposes significant changes to other pieces of legislation, which will, amongst others,
I'm sorry. Please speak closer to mic because you are cutting at some point. Thank you.
Okay. I'll try. I think it's the network because I see it says my network is unstable, but I'll try to speak louder. On clause 58, the NHI bill proposes significant changes to other pieces of legislation, which will remove the responsibility of employers to cover care costs of workers injured on duty. And then the change of the pricing regimen for medicines and medical devices and make significant changes to the NHA, which will alter the delivery and functions of healthcare. There's no clear replacement of these systems. The implication of these repeals and amendments are not adequately explained or understood. In terms of the recommendation, it was said that the interaction between the bill and all pieces of legislation outlined in the schedule and the implications of the proposed amendments should be clarified. It is proposed that instead of proposing amendments to key laws in the schedule to the bill, these laws should be amended to allow proper consultation. It is suggested that the Nursing Act be amended to enable and regulate independent practice by nurses in the private sector. It is proposed that clause 58, subsection 2 be deleted since the Interpretation Act of 1957 regulates the effect of the repeal of law. Under the Medicine and Related Substances Act, the short title is incorrect. Compensation of Occupational Injuries and Disease Act, the words notwithstanding would, after the in paragraph A, in paragraph B of section 22, subsection 3, would, after the proposed deletion of paragraph A, be no longer necessary. The Road Accident Fund, clause 1A, is problematic. It requires that liability of the ref or an agent regarding any tariff shall be based on the reimbursement strategy for health service is contemplated in the bill. It is submitted that if consultation is required, then the appropriate functionary is the NHI, not the Minister of Health. The road, further on the Road Accident Fund, if the sections proposed by clause 1, subsection B are deleted, then a consequential amendment must be made in section 17, subsection 4B to remove reference to the deleted subsection 5 and 6. A National Health Amendment Bill should be published, which contains all the proposed amendments and to which comprehensive comments can be submitted. There was no input under clause 59. Just some additional comments from stakeholders on the limitation of the bill to its objectives. The reviews that only purchase and funding of related powers should be. It was argued that the NHI appears to step into the domain of regulating and organizing providers on constitutional issues, the inclusion of medical emergency services that are under the constitution must be provided and funded for by the province, and the removal of central hospitals and staff as well as district health structures from their current provincial powers and employer to the National Department of Health. The NHI may possibly be violation of Section 217 of the Constitution by excluding the Competition Act. Could be problematic and distract from price negotiation system. On the legal framework, the current version of the bill provides an adequate framework for the infrastructure and capability needed to achieve the desired outcome of health providers are bound by laws such as the POPI Act, the Consumer Protection Act. It appears that if both acts are excluded from the NHI bill, as it may contradict with the provisions or in the bill, this is a major concern. Consumers have no independent recourse in the current NHI framework. On the system design issues, that there's no evidence that a single purchase of will result in cost reduction. The NHI does not propose the establishment of a single purchaser model. The single payer system versus a hybrid model, it is argued that countries such as Thailand, France, Chile adopted a hybrid model which created for specific population groups that are more likely to have an efficient and responsive healthcare system. The single payer system is set to disrupt South Africa's healthcare market dynamics in 3 ways. Huge power will be toward any competition that comes its way through cross-subsidization of the poor by the wealthy, the sickly, by the health and the old and the young, and by the young through per capita payment to providers as the state and through the Office of Health Products Procurement that will determine the fees that private doctors may charge their patients and restrict billable. A role of medical schemes submitted that potential constitutional challenges arise from limiting ability of medical scheme beneficiaries to access services, preventing medical scheme beneficiaries from accessing healthcare services, voluntary private insurance at odds with the responsibilities of the state. National health systems across the world exist alongside private healthcare systems. As the HMI report indicates that competition promotes better health outcomes, the rationale for restricting the ability of medical aids to offer priority cover to NHI is not clear. The reduced role of the medical schemes will not address the current barriers to access healthcare services. Financing on NHI, any imposition of taxes falls within the remit of the Minister of Finance and must be dealt with through a money bill. It should be noted that the Davis tax has expressed its reservations in its report to the Minister of Finance. It was recommended that mechanisms to contain the administrative expenditure of the NHI must be prescribed to ensure that the majority of the funds are used for healthcare benefits and not for operational expenditure. Governance of the fund. In the bill, governance and decision-making are to a larger degree centralized in the office of the minister and limited number of committees. This poses a risk as it becomes a very centralized decision-making process, which is not in accordance with good governance principles. In addition to not meeting the standards of good corporate governance as recommended, it will also entrench significant political power, which is to avoid the context of the current economic challenges. Legal requirements and clinical elements of the system must be rational, objective, transparent, and not open to political interference. It is advisable in terms of good corporate governance that they function relative to its object and purpose. I leave it there, Chair. Thank you.
Thank you very much. Did I hear you are done, Ms. Ngumane?
Finish, Chair. Thank you so much.
Thank you. Thank you very much. Let me thank Honorable Munyai for keeping the fort while I was struggling with getting my gadgets charged. It has been a serious challenge to many of the members today. But thank you very much, Ms. Ngumane, firstly, for this report that was drawn up by you and your team. And secondly, for the presentation that you had just done on this report. There were slight challenges with hearing you now and then, but fortunately the report was flighted and honorable members could also read what was put on that report. Honorable members, I'm going to allow discussions, and please be reminded that the question, whatever you raise, is not for questions to Ms. Ngumane. She's not authorized to ask to answer questions. She's not a politician, and that whatever you note would be comments by yourself in terms of the report itself, the matrix, and it will be noted as such. Thank you very much. I'm going to take the hands. It's Honorable Wilson. You must also excuse me, I'm now on my telephone and not on my laptop. You will hear a bit of a buzzing noise in the background because I've had to make some other plans to get my gadgets charged. So that, please just ignore that noise. It's Wilson, Munyai, Clark, Van Staden, Chirwa. Any other members? Gela, Kaba. I'm going to repeat: Wilson, Munyai, Clark, Van Staden, Chirwa, Gela, Kaba, Ismail. Ismail, anyone else? Let's start in that order, honorable members. Once you have completed, please ensure that you take down your hand again so that I am aware of who has completed, and if anybody wants to maybe raise their hand again and maybe for a point of order or an objection or maybe a second input or clarity, etc., I'd be able to see when your hand is raised again. Thank you. In that order, honorable members.
Thank you, Chairperson. Chairperson, given the extent of the changes proposed in this presentation and the high probability of unintended consequences arising from this, there must surely be grounds now for a technical feasibility assessment and further public and stakeholder hearings. I think this will be very important. I must say, however, that this document does not appropriately address the concerns we raised, and quite frankly, I think it must be rejected. Thank you.
Thank you. Munyai.
Thank you very much, Honorable Chairperson. I must say that I'm noting the report, and noting the report should not be misunderstood as if I'm agreeing with the report. For instance, the area where the recommendations say that this issue must be done by Parliament, the board must be dissolved by Parliament. No, I know that the cabinet have the capacity to do that through the consultation with the minister or process through the minister. And the issue of arguing that the minister have excessive powers. How can it be excessive if it's based on the constitution? There are numbers of areas I don't agree with the bill, but I want us to note so that we can move. And again, noting does not necessarily mean I agree with this particular document. I should put that disclaimer. Thank you very much. There are a number of areas I don't want to comment because as you advise, you said the presenter is not politician presenting political issues, but no problem. We're moving forward, I've noted.
Honorable Clark.
Chair.
Thank you, Honorable Clark.
Chairperson, thank you. The report is noted, but I have to highlight, there are a lot of issues that were raised in this bill, around this bill in this presentation. And there was very little feedback in terms of addressing these issues. And that I find very disappointing. And I'm hoping that tomorrow the department is actually going to address the issues in terms of the feasibility studies, the financial model, the critical issues around transparency in the bill that's been raised. And many of these concerns raised in this report were many issues that we raised during our deliberations during the clause by clause deliberation. But no real feedback on this document to say what is actually going to be done to address the array of issues that have been raised, and that's what we need, Chairperson. I mean, to sit here from 10 o'clock until just after 12 and listening to all this, but no concrete feedback. That's the problem here, Chairperson. So until we get that given to us as a committee, we reject this kind of meeting. I mean, for me, we got nothing out this today. Thank you.
Thank you, Honorable Van Staden. Honorable Van Staden.
Thank you, Chairperson. Yeah, this meeting is difficult today with all the signal dropping and everything. We're very plus taken the report, our previous speaker said, we've been deliberate the clause by clause from Men's Committee. And in my view, didn't receive adequate answers, and the past months in this committee. However, Chairperson, there's another matter, and I'm going to bring it up now. Remember last year, this committee appointed the external service provider, the written submission, 1,000 written submissions. And earlier this year, we received a report from the committee total of submissions was from different sectors received. That is fine, that is no problem. The quit earlier this year as well, and we've heard from the minister, I think earlier in this committee, the department is still busy compiling. But this committee must know how many over 338,891 submissions which raised to Parliament. Total of people who work for in the submission against the bill in that submission. So I think that is now in the critical stage, but we do receive feedback on that matter. Thank you, Chairperson.
Thank you. Can I repeat what you're saying? Because we lost you in between, Honorable Van Staden. You're saying feedback on the submissions made, written submissions. Honorable Van
Chair,
Staden.
I'm
Yes,
going to try again.
Yes.
On the written submissions which was made to part 38,000, we still need to get feedback on how many of those submissions were in favor of the bill and how many against the bill. So that is crucial that we need to get that feedback. We did get a report from the committee to state the total number of submissions correct, but need that report. I think for the department, the minister said in this year, I think it was in June when we were in the Taj Hotel, but we're still busy compiling that report and we need that report. Please, Chairperson.
Thank you, Honorable Chirwa.
Thank you very much, Chairperson, and thank you to the people who made the presentation of that report today. I think my concerns are as follows. Firstly, is that it's not fully encompassing the issues that were particularly raised in this portfolio committee. I think there should be an appreciation of the work that the members of this portfolio committee have done over the past months in deliberating on each clause. And also, there should also be, there shouldn't be a stagnance, right? I know that this is a very, I don't want to say logical, but like a, how do I say, like a distinct, precise, concise process, right? Because it's legislation and stuff like that. But I think in stuff like the reports and whatever, there should be an opportunity to make a contrast of some clauses to the other ones, or some aspects to the other ones, because they're not in isolation most of the time, considering what we have been contributing also in this portfolio committee, and also considering the fact that we are rejecting the bill in totality as the EFF. But stuff like, for instance, a big red flag that the minister raised last week is that part and parcel of funding the NHI is a reallocation of funds in the NDOH, right? Which was raised as a big concern, but also in contrast to the clause that speaks about the referral system. So it's those kinds of situations where we are reallocating funds and don't have a clear picture of where this reallocation is going to happen and stuff like that. And thirdly, I don't think the infrastructure deficiencies and the issue of exclusion in relation to what I just said above there is something that should be engaged much more intricately, because I mean the ANC is going to do the NHI whether we like it or not, because you guys have been entrusted with people's votes, and people will have to learn how the power of their vote by seeing the NHI happen and seeing how it is going to affect them negatively. But in those processes and us engaging, there should be room to the very least, you know, because we have our own ideological standpoints of the fact that this bill will cater the private sector because it's officiating the tender system in the healthcare system, which is problematic. But nizoyenza, regardless of all of those things that we are raising, despite that the ANC usually presents itself to the people as a socialist party, or just there in the center, not necessarily socialists, but just in the center, right? But the fact that these things are happening, and as a committee we are overseeing them, regardless of political allegiance and political loyalty, should raise a problem for all of us, because these will have our names stamped on them as people who participate in this process. And so it happens. So things like the referral system, things like wanting to know how the funding is going to happen, things like bureaucracy and transparency, things like giving the minister too many powers. I think as a portfolio committee, these are things that we should not just sideline, and should ensure that they're encapsulated in everything that has our name on it properly, because those are strong points that we are raising. And secondly, I just want to emphasize to the chairperson that the request to have the Minister of Finance to come to this portfolio committee and appraise us on the funding system of the NHI needs to happen as a matter of emergency, honestly, especially with things that the minister has said last week on reallocation of funds in the NDOH. We don't know from which departments, we don't know from which programs, we don't know from which facilities, we don't know from which provinces that this reallocation of funds is going to happen, and to where it will be taken to. Will it be taken to supply? Will it be taken to deliveries? Will it be taken to service providers? How does this reallocation of funds look like? And if there are no answers to these basic, because these are basic questions, to be quite honest with you, these are very basic questions and should be answered before we even ask them, if we're talking about a whole overthrow or a whole implementation of an entire new public health system. So these are questions that we shouldn't just overlook. And you know, the minister is a grown man. He shouldn't be defended from the most basic of things. Honestly, how are you going to fund this bill that you are pushing for, that you are being protected for, that you can't even answer questions for, because they're being defended by members of this portfolio committee on responding to the very simplest of questions? I think as a portfolio committee, it should worry us that we are okaying a bill that we don't know how it's going to affect the public purse. And there isn't even an engagement with the Minister of Finance, because the Minister of Health doesn't know, quite frankly. He doesn't know, and he gives us essays on issues that need numbers, that need an estimation of figures. We need figures, and we have not gotten figures in relation to the NHI. And I might be digressing a bit, so I'll just leave it there. Thank you very much, Chairperson.
Thank you, Honorable Gela. Honorable Gela. Honorable Kaba.
Yeah, thank you, Chair. Chair, I think Honorable Mnyai had already outlined that we note the presentation and really it registers progress. We are going forward. But Chair, the other thing we must also clarify is that the ANC has considered all these suggested changes, and where it makes sense, we'll table changes to the bill. And the ANC Chair has seriously analyzed the submissions made by stakeholders and made positive changes where it's necessary, clause by clause. The ANC Chair notes the report and has considered all the suggestions and comments as raised in the report. In its written comments, the ANC has factored these where it makes sense and has tabled comments proposed by the bill in our written comments. And Chair, as does the ANC, upon the provincial hearings, we consider them and address them in the discussions of the NHI bill. So Chair, I think we are registering progress and we note the report, and I think it registers progress, Chair, like as I raised to support Honorable Mnyai in my presentation. Thank you, Chair.
Thank you, Honorable Gela. Are you back? Honorable Ismail.
Thank you, Chair. Unfortunately, I would like to say that, 85 to 90% of concerns raised by stakeholders.
Recording stop. Recording in progress.
So unfortunately, I would say 85 to 90% of concerns raised by stakeholders and recommendations are actually not effectively addressed in this report. Most of the time, there are no real amendments that actually effectively address, matters raised. With consequence, or what I'm trying to actually raise here is to say that it has not been actually properly stated. It has not actually been said, how is this particular point or this particular issue raised going to be addressed, and what is the consequence when it comes to monies, necessary to address this particular issue raised. So I believe this report actually lacks lots of issues and recommendations raised, and no effective financial consequences and financial feasibility studies responses has been provided. And this is things that we've been raising even as members of parliament in this NHI whole hearing process, that we need this information, and unfortunately this report is really lacking a lot of information that is crucial. Thank you, Chair.
Thank you, Honorable Harvard.
Thank you, Honorable Chair. Firstly, thank you, the presenter. Have a 2-hour full presentation. I fully agree. This report already takes some recommendation and did a good amendation from the public. ANC also seriously took the comments made through written and oral submission, even from the provincial hearings. I think this is a good way to process. The ANC already used in making changes where necessary, and we just short of a little bit more time. We need to spend more time recheck the contents. Otherwise, I think the latest report that is perfect, we can go forward. Thank you, Chair.
Thank you,
Chair, I'm back.
Honorable Gela.
Thank you very much, Chairperson, for the opportunity. Chair, I rise in support of the submission that Honorable Mnyai made and also Honorable Klaba. It's correct, Chair, what they are saying. And really, we must listen to the voices of the masses. I think they've said it mouthfully that NHI is the way that we must take as South Africa. And you are correct, Chair, when you are saying the presenter, it's not politicians. We must also think that as honorable members. But Chair, I rise also to note the presentation, Chair, as presented before us, Chair. Thank you very much.
Thank you. Honorable Munia, I see you raise your hand again.
I apologize to this legacy hand.
Thank you very much. Is there anyone else, honorable members?
It's Sheikh Imam, Chair.
Honorable Sheikh Imam.
Yeah, thank you very much, Chairperson. Thank you for the opportunity. Sorry, I've been attending another meeting as well. But yes, Chairperson, I think I must agree that the NHI is imperative in order to address the inequalities, particularly in healthcare in the entire country. And I can understand the submission from the masses that we need to introduce this. We need to introduce it as a matter of urgency. So I don't have a problem with that, Chairperson. And I think for far too long in the country, particularly the masses, based on what we inherited after the days of apartheid, have been marginalized, victimized, and not provided with equal healthcare. So I think we need to address them. However, Chairperson, my concern is this, and particularly around the issue of funding for the NHI at the different levels. There's many questions that remain unanswered. Now, my concern is this, that whilst we are going to adopt this and introduce it, but if there are unanswered questions, is it not our responsibilities as public representatives, legislators more importantly, to be able to interrogate that and find those answers? Because we will introduce it, and then what, Chairperson? Are we going to find ourselves wanting when there's going to be problems? So if we believe that there might be problems, my suggestion is, Chairperson, that we should explore that and try and close those gaps and get answers for that, so that when it is introduced, it will be a success, which is what everybody wants. I'll stop there, Chairperson. Thank you.
Thank you very much. Any other members? So, honorable members, today, as I said, it's not for answers from Singumane. It's for us to discuss, which you have done. But I think from my own position, there are just one or two or three items which I need to speak to, which had been raised by the honorable members. Firstly, this document was drafted by the staff of Parliament. The National Department of Health had nothing to do with this document. The second thing is that Parliament does not do feasibility studies. And I know that's probably, hopefully not what the member was saying, but just to remind us that Parliament does not do feasibility studies. The staff who presented this document, drafted it and presented it. It's part of their normal duties which they have to perform. Then thirdly, it's part of our normal duties to have the document serve, this particular document. And this document, just to remind you, it is a courtesy, it's a nice gesture that is performed, that is done by myself and the staff of Parliament to make it easier for all of us to understand where certain points are raised in terms of the public hearings, or let me say, the public engagement processes. You will be reminded that you had received the reports. And if I'm going to try to remember what it's called, the one is called the clause by reports on the clause by clause, on a clause by clause basis. The one is called the thematic report. The other one is was a PowerPoint presentation, and there was one on the provincial public hearings. In that particular email, there were those 4 items, which you had received some time ago. So the point the point that's being raised that there has not been an opportunity to give input on it is not true, because the input is supposed to be brought by yourselves, honorable members, as we were continuing with the deliberations, having been sent those reports by our committee secretary months ago. So then on the external provider, it's also in the report, because remember we had discussed long the assistance that was required by a Parliament for the capturing of the data. Now, in terms of Honorable van Staden's point of feedback on the written submissions, it's all captured in those documents. This document actually enhances that document, because it now brings the most salient, most generalized, or most regularly expressed views in the format that we brought today, and we've now brought it to the Portfolio Committee, also for you to engage with and to bring up at any point in time that you think it is necessary to do that. I will come back to you, Honorable van Staden. I see you raised your hand. Then, in terms of where we are with regards to the suggestion that was made that no amendments were made in this document, it shouldn't be that any amendments should be proposed by the staff of Parliament. It's your position, it's your work, it's my work, or us who must propose those amendments. And you would remember that you've been asked many times to send the submission based on amendments or recommendations, anything which you needed for us to discuss and for the department to note, and for the legal teams, 2 legal teams to note, should have been sent, and we will still discuss that, whatever was forwarded by the political parties, those representing the political parties in the multi-party committee. That is what was requested. That's where it goes. That's where you make those suggestions, and not in this particular report. And so that includes many of the issues which were, of course, raised by many of you. So with that having been said, I'm first going to hand back to Honorable van Staden. Excuse me, and then we will talk about the way forward, honorable members. Honorable van Staden.
Chairperson, I think you misunderstood me. I've got the report in front of me, which was given to us on the 15th of March. Now, if you go and look on page 13, that's exactly what I said. It did mention there on page 13 of that report, the total number of submissions that was received by Parliament. There's a figure there which states figure 2, total submissions received by the committee, so many emails, so many complementing emails, total email submissions, hand delivered and all the stuff, and over the total submissions of 338. My question is, we did not yet receive a report to say how many of these stakeholders or people who made these submissions were in favor or against the NHI bill? That is what I'm referring to. I think you were just misunderstanding me there.
All right, thank you very much. I do know what you're saying. Your emphasis is on that last part, and it's not something that I can answer you now. It has to be noted, maybe for another answer at some other stage. So let's note that, and I can't, as I said, really answer that. So honorable members, what has now transpired is that we've had the deliberations. Well, the public has had deliberations, and we've had deliberations. We've looked at the bill, we've made the recommendations, various political parties, points which were raised, various points which were raised. The department was supposed to note all of those and then respond to those points tomorrow. So tomorrow is the day for the department to then answer. So today, we had nobody who was going to answer to any of those points raised, because we are the committee and we brought a document for noting. So tomorrow you're very welcome to raise all of those points again when the National Department of Health comes to bring their views to the Portfolio Committee. Now, just to tell you, so also on Friday, we will have the Legal Services of Parliament and the State Law Advisor Office coming to give us their views again on what had been raised in all of the processes in terms of the legality and the constitutionality and all legal points raised by us, public engagements, and the department's responses. So by Friday, we should be up to that position where we have a better idea of many of the points raised, as Honorable Sheikh Imam called it. He said unanswered questions. So hopefully by Friday, we would have many of these questions answered, and hopefully all of them answered. The week after, we will have to, once we've done through with the Legal Service of Parliament and we come to an agreement as a portfolio committee on what had been raised by them, they will then receive an instruction that they must go forward and start developing the A list, which would be any amendments proposed to the bill as it is currently, which they would present to us again. And we then have to give them an instruction to go back again and to write up the B bill. So the B bill is the bill that comes back to us. We decide to adopt it or not to adopt it. Once we've gone through that, we go back and we go to we go back as a committee and we decide to adopt that as a report. We adopt our report, including the A list and the B bill, etc. And that would be almost the final stage, where the focus is then with the state law advisors to go and publish that bill, to circulate it, to make sure that it's firstly to make sure after publishing that it's correct, to reread, make sure it is correct in terms of the legal vocabulary or legal jargon or the needs in terms of the constitutionality, etc. And then we, honorable members, will adopt that report. We will seek to adopt it, let me put it that way. And then after that, it gets circulated and it goes to the National Assembly for a second reading debate. I thought I would share this with you so that we are all aware of what the processes are going forward now. Having said that, honorable members, we've come to the end of this meeting. I don't think there's anything else to raise now.
Thank you, Chair.
Thank you very much. Ms. Machalamba, I just want to make sure certain is the department, having the department tomorrow at 9:30 or at 10? And I know you've been struggling to if you on the system. I can have a look. Just a short moment. There's the agenda. Well, it's not that one. Just a short moment. Let me go look at the. Is there anyone who knows?
Chair, the notice sent to us states 9:30 to 1 o'clock on the 23rd of November.
Thank you very
Yes.
much. Thank you, Honorable Ismail, for saving me that effort. All right, honorable members, thank you very much for your attendance today. We will meet tomorrow morning at 9:30. And have a wonderful day and evening. And we'll see you tomorrow. This meeting is adjourned.
Thank you, Chair.
Thank you, Chairperson.
Thank you, Chair.
Thank you, Chair.
Recording stopped.
You.